maybe 10, 12 more minutes. Hassan, let's start with you.
Thank you. I was saying our own mandate at the ICTR is to deal with, prosecute serious violations of international humanitarian, not every offense, and understandably so, because the situations in which international criminal justice gets involved in are situations where you have usually thousands of victims and hundreds, if not thousands, of perpetrators. It becomes impossible to prosecute everybody. So there is a real problem of selection of targets you are going to deal with. In Rwanda, at our own tribunal, we had to consciously address that particular issue. On what criteria do we select cases that we are going to prosecute? Because we recognized that we couldn't prosecute everybody. And as prosecutors, trial attorneys, we got together over a period of some days and discussed a number of criteria. We said they have to be serious violations. Serious can be defined on the basis of the level of involvement of the person, how notoriously involved was the person. But more importantly for us was the status of the person as well, the status of the person. If our theory, sorry to use the word theory there, if our case was that the genocide was something planned by the government, it meant that every member of the government with the slightest evidence of involvement had to be prosecuted. So we looked at status therefore as having priority over level of involvement in that particular case. Then we looked at level of involvement. We looked at the nature of the offenses which were alleged to have been committed. If it was a sexual violence offense, of course, we said, because it was such a widespread aspect of the genocide, people who were alleged to have committed sexual violence ought to be prosecuted as well. But that still leaves us with a huge list, which we are unable to finish by the end of our completion strategy mandate. So what we've then had to evolve again, the issue of the strategy of referral to national jurisdictions. And this we hope will help us move away some of those cases to national systems. Of course, we have to base the prosecutions on the evidence. The evidence has to be there. Even if you are a member of the government, we have to have some evidence of your involvement. Many of these top-level people don't literally have blood on their hands. They may have planned the genocide, but they sat in their offices and do what was done. You never found them at the barricades with machetes in their hands. So that becomes a real challenge. How do you prove the case against members of the government, against these high-level people, without whose involvement the genocide would probably not have happened? And there we rely sometimes on what we call 6-3 responsibility under our statute. We rely on insider information. We find a number of them who are within that group itself and turn them around for them to cooperate with the prosecution. They confess themselves, of course, to their own involvement and implicate their colleagues. We don't let the insiders go off scot-free. We insist that they must confess to their crimes and plead guilty, and then we can then use them as prosecution witnesses against the others. But that has been our approach. First, we decided to define the criteria by which we could select the targets, and then we defined the strategy as to how we could reach particularly the high-level targets through a system of insider witnesses and also through the use of the 6-3 responsibility.
You've just benefited from a superb insight into the work of the prosecution. Robert, a quick follow-up, maybe David, a quick follow-up, and then I want to move on to another subject or an audience question. Yes?
I just want to point out that whatever prosecution strategy we develop and however much whatever ways you define it and publicize it, you have to be able to explain to the people what it is. I think I was there at the very, very beginning, so one of the failures of ICTR was that we failed to do that from the very beginning. Outreach was null from the beginning. It allowed the government, NGOs, civil societies, whoever, to basically manipulate what was going on in another country, in Arusha, to the people who were only concerned, the Rwandans. As opposed to Sierra Leone, where I think, to my mind, it was the best outreach program where we were pretty good at telling people why we were doing what we were doing, and perhaps more importantly and with more difficulty, why we were not doing certain things. In Cambodia, we have 30 years of expectations of the population who want to know what happened, why it happened, and a certain number of population obviously want the retributive aspect of this process. You have to be able to explain to people what you're doing, why you're not prosecuting the guy with the knife, or why you're not prosecuting somebody, for example, in Sierra Leone, which I still don't agree with you, Dave. A guy who was called, a guy who should have been prosecuted, who was one of the worst perpetrators, but who was not one of the greatest responsibility, but who, in the mind of people, was clearly associated with the conflict. So represented to them, or could have represented some kind of legitimacy, some kind of credibility to the process, because the people that they hear the names on the radio or never seen, the leaders usually, are not the ones who matter most to people, to victims. They're the ones who kill their kin. Those ones matter, or the ones that they know were in the area. So you have to be able to explain to people why you're not going to be prosecuting them. Don't expect them to make them happy about it, but you have to have the honesty and whatever you need to go in front of them and explain to them what you're doing. I think that's as important as getting a strategy together.
David, a quick one?
Well, I had a couple of points, but since Roberto mentions this, I don't think anything's more important than having an effective outreach program from the prosecution, but also from the court as well, because if you take the example of the former Yugoslavia, you're in The Hague, you're a long way away, different languages, different legal systems, new concepts that have never been understood by the person on the street. So there's a lot a great deal to explain there. Just coming back to what Hassan said about the prosecutorial strategy at the ICTR, ours faced a little bit different problem in that we had 4 or 5 different conflicts over a 6 or 7 year period. So we could have spent every last moment investigating Srebrenica. We had 8,000 men and boys killed on one night, but we also had 3 or 4 other conflicts that went over that 6 or 7 year period. So sometimes you end up in a situation where you're comparing apples and oranges. In Kosovo, the number of people who were killed is much, much smaller than, say, in the Bosnian conflict. However, for us to have done our job, our mandate properly, we had to invest in Kosovo as well. And there's some extremely difficult decisions to be made there. On command responsibility, I think I agree with Luis, because I think in the ICTY at least, we see command responsibility 7.3 under our statute, 6.1 under the ICTR statute. That's indirect responsibility. That's the failure to punish or the failure to take action to prevent these crimes, to be treated almost like an administrative crime. So we have the Orage case where he failed to prevent murder and he got a 2-year sentence. And I think perhaps you're right, Luis, that if you look at the jurisprudence of these tribunals, this is not being taken particularly seriously in comparison to direct responsibility under our statute, under 7.1. So I think those are some of the things that you have to take into consideration in making these decisions.
Stephen?
Yeah, I want to emphasize that at the international level, this is only part of the answer and part of the response to these crimes. And at the international level, we've discovered that these cases are expensive. They're extremely difficult to put on. There's only a limited number of cases that you can do at the international level, and that was the principle that underlied the Sierra Leone court, where we were limited only to those with the greatest responsibility. But the design that we all hope for is that there's a response within the national systems to other lower level offenders. Now that can be a truth and reconciliation process, that can be prosecution of regional leaders and others. But it's very important to reinforce that. And of course that underlies the Statute of Rome and the concept of complementarity, the idea that really the state should do these cases first, and the ICC only becomes involved when the state is unwilling or unable. Certainly in the former Yugoslavia, there's been a great deal of work in terms of dealing with local prosecutions and sending cases back to the region. The same thing is being done now at the RWANDA Tribunal, and of course RWANDA itself has been prosecuting more than 100,000 people that it arrested. In Sierra Leone, we have the particular challenge that even though there was a truth and reconciliation process, there really hasn't been any prosecution of mid-level offenders because of national capacity problems. And it remains a challenge. As we go out there in these outreach meetings, they're constantly asking us, what about this guy? What about that one? What about that one? And we say, that's really a national issue. And then we explain what we do. which is to go after the people with greatest responsibility, the people that gave the orders that sent those men out there, the people that recruited 12-year-old Dr. Chop Chop who chopped off the arms. It wasn't the 12-year-old that was responsible for what happened there at the end of the day. It was the people that deployed him for their own greed and power. And that's our job, but it's only part of the job.
But Steve, don't
Thank
you
you.
think that's kind of the missing link here in a way? Our job is very difficult, but and I've been working very closely in Bosnia with the state court in particular, and you were in Sierra Leone and so forth, but it is really the missing link, the local capacity. And the idea that there is a partner out there is, right now, to be honest, pretty much a fiction. And we have a huge job there. Perhaps this is for this afternoon, but I think this is one of the biggest challenges that face us. Because, as you say, financial pressure, you must finish up, top-level people, refer the rest of your cases to local jurisdictions. These local jurisdictions have been just decimated by war. Some countries, like Rwanda, you have a handful of lawyers in the entire country. So we're getting instructions from above, whether it's the Security Council or whatever, and there is a big missing link, and I think it's worth at some point discussing that link, because it is the issue, in my view, that we've got to deal with for the future.
And I would hope that perhaps in the next session, Layla, I wanted to get into the peace versus justice discussion, but I think we could link that with what David has suggested in terms of domestic capacity building and how important that is to the future of literally international criminal justice. What I'd like to do is, I know we're running short on time, but I would be remiss not to allow at least one or two questions from the audience. Would there be a question? Yes, in the far back. Yes.
Rwandans in Rwanda or Sierra Leoneans in Sierra Leone with possible spillovers around. And I think at the ICC, you have your 4 cases that are focusing on Congo, Darfur, but it's basically within each of those nations with possible spillovers. If I'm wrong, correct me on that. But do you ever think, or as part of your contemplation looking to get at somebody, the things that they've done in a whole region that may not be directly inside the country, but it's had an effect on everyone around it, and that was the central part of the crime. They didn't do much in their country, but they did a lot around it, and that is the crime.
Okay, Ben, let me direct that response initially to David Crane, because I think you'll have an interesting response, David. Please.
That is a very good question, and I think really one that'll bleed very nicely into what we discussed, the future of international humanitarian law. But it was really, in West Africa, it wasn't just Sierra Leone. It was, as you know, culturally, this conflict was going on from Senegal all the way to the borders of Nigeria and even spilling over to Nigeria. But yet, the international community specifically gave us a very narrow mandate: prosecute those who bear the greatest responsibility related to offenses that took place in Sierra Leone. But there were many, many actors, boy generals, financiers, international criminal cartels, 3 sitting heads of state involved in the region that were directly implicated in causing the suffering that took place that, at the end of the day, caused the murder, maiming, rape, and mutilation of over 1.2 million human beings. And so when you come in here with a very narrow mandate, how do you shift all that through and decide who you do, in fact, prosecute? It is important that the regional aspect of these hybrid international war crimes tribunal, for example, try to capture not just the local but also the regional aspect of it. And you can do that in many ways. You can do it by the indictment itself. You can do what we call name and shame, which we did with Muammar Gaddafi and Blaise Compaoré. Or you can also, through the evidence, either through mapping the conflict or putting in evidence in court, show the world that not only was this a very narrow tragedy, but there were many, many actors. And I would posit to you as we go into break, will we be able someday to find a multinational corporation individually criminally responsible for war crimes and crimes against humanity? We had many debates, usually over a glass of beer or coffee, as to whether there's a certain corporation in West Africa dealing with blood diamonds that might be liable for the war crimes and crimes against humanity that took place in Sierra Leone.
Hassan?
Usually these conflicts or these atrocities, they may take place within the national frontiers, but invariably there is always a spillover to the region. I think you're right. In most cases, the mandates of the tribunals have been to look at what has happened within a particular state. In our case, though, in the case of Rwanda, there was also quite a serious spillover into the DRC, the Congo, and some of the neighboring countries. And there, the Security Council did depart, in a sense, by giving us the mandate to prosecute not just what happened in Rwanda, but also prosecute all Rwandans who may have committed offenses in the neighboring countries as part of that process. But unfortunately, we are overwhelmed by the amount of work we have to do just in relation to Rwanda itself, the genocide. You're looking at having to investigate almost 1 million murders, investigate about 1,000 perpetrators. The Rwandans themselves have had more than 100,000 people in custody for local processing. So we really did not have the ability to go beyond Rwanda and investigate what had happened in the DRC, in the Congo, where at least 1 million people also died in the camps out there. So we were given actually the mandate to do that, to go beyond Rwanda and look at what happened in the region. But because of time constraints under the completion strategy, we have to close trials by the end of next year, constraints of resources, the magnitude of what happened in Rwanda. We've not been able to exercise that mandate altogether.
Let me,
David,
yes.
David Crane was perhaps too modest in his response because, in fact, your court did, and you did indict somebody who was outside the region, Charles Taylor.
Charles Taylor, leader of Liberia.
Well, you know, it's an interesting thing. I had to make a terrible political choice. I think we could have indicted Muammar Gaddafi and Blaise Compaoré. Blaise Compaoré is the sitting president of Burkina Faso, and of course we know who Muammar Gaddafi is, really one of the individuals who really created all of that tragedy in West Africa. But if I would have indicted 3 heads of state, then the international community, particularly the United States, would have pulled the rug out from underneath the tribunal and would have shut us down, in my opinion. And so I had to make a very balanced decision. Who do I pick to indict? And certainly the center point of this was one of the key protégés of Muammar Gaddafi was Charles Taylor. But can you imagine if I would have indicted Muammar Gaddafi? We may not even be sitting here today as far as the Special Court for Sierra Leone. So you have to, there's a political dimension to being a part of all of this. And you have to be very mindful of it because the international community can choke on what you're doing, and literally we could throw the baby out with the bathwater if we're not careful.
Well, I see raised hands. Gregory, I guess I'm in your hands, figuratively speaking here. Okay. Well, why don't we pause? Hold your questions, please. We'll make sure in the next session that we focus on questions. I just want to close by clarifying one point or elaborating on it. I noticed during Whitney Harris's just splendid address to us that when he described the vote in Rome on the Rome Statute for the International Criminal Court and the fact that the United States voted against it, there was a very understandable collective groan in the audience. Because this includes sort of a general audience as well as specialists, some of you may not fully be aware that although my instruction from Washington that day was to vote against it, one which led to some shouting over the telephone, etc., the reality is that 2 years later, on December 31st of the year 2000, the United States, represented by myself, actually signed the Rome Statute. So we became a signatory to the statute on December 31st of 2000. What happened a year and a half later in May of 2002 was that the Bush administration effectively rendered that signature of no legal force and effect with a letter to the United Nations. And that's why we have this sort of sort of understanding out there that the United States is not a signatory to the treaty, when in fact we still technically are. And I hope that within a few years it'll be far more than that. Thank you very much.